So welcome everyone to the employment session. We'll be talking about AI and employment. My name is Allison Buchanan. I'm counsel in the Dentons Toronto office. My practice focuses on helping employers run their business and manage their workforce. With the advent of AI, a lot of that is also providing strategic advice about how to manage AI in the workplace and the risks and benefits of it. And I also regularly represent employers at all levels of courts and tribunals in Ontario. And I'm here with two of my lovely colleagues, and I'll let them introduce themselves as well.
Hello, everyone. My name is Larysa. Workewych. I'm a senior associate in the Toronto Labour and Employment Group. My practice is very similar to Allison, so I'm not going to repeat myself or anything so that we can get started on the real meat. But just to say that I do work with both federally regulated and provincially regulated employers on a number of various employment and labor matters, as well as have a fairly extensive labor practice itself.
And hello, everyone, again. Peter Stockburger, partner in San Diego. And if you're wondering why am I back up here, it's because for the past 15 years, I've actually also been an employment lawyer in California. I came up as an employment law associate. So I have a unique intersection of expertise on both AI and traditional employment law from a US perspective.
So the reason why we have Peter up here with us today is to talk about some of the interrelationships between what's happening down in the United States in terms of lawmaking around artificial intelligence in the employment sphere and up here in Canada as well. AI has quickly become part of the whole employee life cycle, and it's been integrated in a lot of human capital management companies and built right into their systems. So we're seeing it validate payroll information, generate reports, automate task reminders. We're also seeing it in the entire applicant tracking system. So from fielding resumes, reviewing resumes, scoring candidates. We're also seeing AI in the workplace monitor employees by analyzing keystrokes, checking email tone, figuring out how much time somebody spends on a task. And the capabilities are obviously very impressive, but of course it also raises some very serious legal questions. So how are we doing in Canada with those legal issues? And we're not quite sure yet in Canada. And I say that because we don't have a lot of legislation. Larysa and I will talk a little bit about the legislation that does exist in Canada that can be applied to artificial intelligence in employment. And there are certainly some steps being taken at the federal level. But conversely, in the United States, there is a fair amount of direction from lawmakers. And so that may indicate the direction that we are going to go in. So Larysa and I will chat a little bit about some of the legislative changes that can be applied to artificial intelligence in the workplace. And then Peter will shed some light on what's happening in the United States.
Yeah, absolutely. And we've started with our session because it is going to be just not as exciting as what's happening in the US right now. Canada tends to be a little slower when it comes to making change. We wanted to joke that we've brought someone from the future because we tend to follow what California does, which is what Peter's going to be able to shed light on later today. But in terms of Canada, what have we seen? Well, the main and really only advancement we've seen has come from Ontario. It is a new amendment that has come into effect that has required employers to outline in job postings if they are using artificial intelligence in the hiring screening process. And so this legislative amendment was recently passed. It's not yet in effect. It's coming into effect January 1st, 2026. But once that comes into effect, employers, if they choose to engage in software that has an AI component to it, are going to need to now start disclosing that on their public job postings. Now, in terms of what is the definition of AI that is being used, it's a machine-based system that, for explicit or implicit objectives, infers from the input it receives in order to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments, which is a really big mouthful that basically says it's really broad, and anything that AI is doing is probably going to fall within that. Now, the change itself is focusing on three key aspects of the recruitment and sort of candidate retention process, which is screening, selecting, and assessing. And all three of those words are really broad, and none of the three of them are defined in the law. So effectively, what this was intended to capture is the use of AI in any part of that process, even if it's not the key decision maker, even if there is a human element that's coming in, taking a look at the data that AI is gathering, the information that's being put together. If AI is at some point touching the process, in Ontario for now, and we're likely going to see other provinces follow suit, the requirement is going to be to disclose that as part of that. Now, it's only a disclosure obligation. There's no consequence for using AI at this time. There's no parameters on how AI should or shouldn't be used when it comes to Ontario employers. So really, we haven't seen a lot yet in terms of proactive legislation from the Ontario government or any provincial or federal government here. What we're seeing a lot more of is directives, guidelines, and we're going to get a little bit into that. But before we do, Allison's just going to shed a little bit of light on the existing framework we have on other components of employment law, electronic monitoring and other pieces like that, that are probably going to be where we start seeing some of the first changes in Ontario and Canadian employment law.
Yeah, well, you might all remember, it was in 2023 when the provincial government changed the legislation to incorporate the requirement for employers who have over 25 employees to have something called an electronic monitoring policy. And at the time, we all sort of scratched our heads thinking, okay, so what are employers really doing? AI really hadn't taken hold. We didn't really know what it looked like. We thought, okay, maybe you're, tracking the delivery guy's GPS, and so that's what we need to record in this written policy. And similar to the legislation that Larysa was describing, electronic monitoring is defined very broadly. It basically just includes any type of electronic monitoring. So of course now we're seeing AI in the workplace, and a lot of what AI does is electronically monitor. So there is a requirement. It's not specific towards AI, but it does capture a lot of the AI technologies that employers are using. And the requirement is to disclose the use of electronic monitoring in the workplace and to provide the purpose for using that information. So why are you collecting it? What are you going to be using it for? How are you collecting it? It's a positive obligation to disclose. What it isn't is it's not a prohibition. It's not telling employers they're not allowed to electronically monitor. It's not putting any guideposts or limitations on what employers are not allowed to do. It's just saying you have to be transparent about it. And so it doesn't provide any entitlement to an employee to not be electronically monitored in its current form. I think when you apply it to AI in the workplace, all of a sudden we're starting to look at electronic monitoring that can be a lot more intrusive on an individual. And so we may see an extension or expansion of the law to address how serious electronic monitoring can be in the workplace. But we're also seeing some prospective legislation coming in from the federal government, and it came in as part of Bill C-27, which completed its second reading back in April of 2023. It's called the Artificial Intelligence and Data Act. And effectively what it's trying to do is, well, I'll read you what the government has described it as. It's a framework proposed as a first step towards a new regulatory system designed to guide AI innovation in a positive direction and try to encourage the responsible adoption of AI technologies by Canadians and Canadian businesses. And effectively what it's doing is saying there needs to be humans involved, and you need to report if anything goes terribly wrong. So you can't rely on complete automation. You cannot outsource completely to AI. You need to have some sort of human interaction with it. And if there's some huge privacy breach or a data breach, you have to report it. It's a positive obligation to report it. Now, this legislation doesn't exist yet. It it was on the cusp of having of coming into force prior to the prorogation and prior to the new government coming into play. So we don't know the status of it yet. We haven't seen, obviously maybe not obviously, there are more pressing matters for the Canadian government right now than perhaps this issue. And so we haven't seen where it's going, but it's there, it's tabled, and certainly the next steps are meant to be a consultation, a broad consultation across industries, and in this effort to try to create this, overarching, very aspirational piece of legislation. And I think there's two other pieces, Larysa, that you can speak to about the same type of thing.
Yeah, and I'll touch on it briefly, and then we'll get to the more entertaining part, which is what's actually actively happening. But what we have seen is, as I mentioned, some directives. Now, for all the lawyers in the room, you're probably thinking it's a directive, it's not binding, do I care what it says? And from a strict legal compliance perspective, maybe not, because there's nothing that you have to comply with at this time. But these are really interesting to flag because they are shedding light on, at least from an Ontario perspective, what the government is thinking about when it comes to its own AI policies that are starting to be introduced or considered. And that's a framework that we will probably expect will then overlay into future guidance and legislation that's coming out of the government. So, for example, there's the Responsible Use of Artificial Intelligence Directive. And this is a directive that was published. It effectively sets out what the government of Ontario thinks are the requirements for transparent, responsible, and accountable use of AI. And Ontario is actually the first Canadian province, again, not to say that we're trailblazers, but we are clearly doing some stuff in AI as compared to our other provincial colleagues. But it's the first province to set out this type of a guideline, to set out these types of guardrails around how AI should be used. And the key thing that I just wanted to pull out quickly before we turn it over to Peter, there's 6 principles that the government has identified as being the main things that should be applied in alignment with existing legislation when it comes to decision-making around the use of AI. So first, AI should be used to benefit the people of Ontario. That seems self-evident, right? You should be using it to move people forward. And what is technology if not good for doing that? Second, AI use should be justified and proportionate. And so it's an idea of we're growing with it. There needs to be a rational basis for doing that. And the use of it has to be proportionate to whatever it is that the purpose that we've identified. Third, AI should be used in a safe, secure, and privacy-protective way. We're not going to speak about that at length. You've had an excellent panel already from our privacy colleagues who can tell you all about that. 4, and I think this is the one that's going to come up most in our discussion for the remainder of today, AI use is a human rights affirming and non-discriminatory process. So I'm not going to spoil the rest of our presentation on that one. 5th, AI use is transparent and meaningful in terms of the decisions that are being made. And finally, AI use is accountable and responsible. So again, this is just one context. This is one government that has said these are the guidelines. But I do think when it comes to decision-making as an organization, when it comes to the development of your own governance policies based on the information you've learned earlier today, looking at how governments and other organizations are framing use of AI and responsible principles around that is going to be really helpful for you then going forward with that. And then the last piece is the trustworthy AI framework. It's connected to this directive that I was just describing, and it sets out a broad number of policies, products, and guidance reports. As of yet, there's all theory. A lot of those reports and products haven't been published yet. But again, there's 3 strategic priorities the government has identified that I think reaffirm where it is the government is going. 1, AI should not be used in secret. And again, I think our privacy colleagues have said enough about why that's the case. 2, AI use should be used in a way that Ontarians can trust its use. That comes back to the ideas of accountability, proportionality. And 3, it should serve the people of Ontario. And again, it's that idea of progress and moving forward. So that's what we're seeing. Again, not a lot of substance, so why don't we turn it over to Peter, who can actually give us some of that substance and tell us what our future holds.
Yeah, thanks. There's nothing happening in the US on employment law. I would say employment use cases are the low-hanging fruit that regulators at both the federal and state level are hyper-focused on. If there's any area of law in the US where we see substantial legislation around, it's use of AI in decision-making in the employment context. So in the employment context, employment law in the US, there's really a couple buckets of categories. You have wage and hour law that regulates what people are paid and overtime and when you have to pay them for meal and rest breaks. You have health and safety legislation about exposure to toxins in the workplace and workers' comp issues. And then you have EEO laws. These are laws that prohibit discrimination, harassment, retaliation, equal employment opportunity laws. That EEO category is where all the legislation is around AI in the US. So at the federal level, we have two laws that get applied in this space. One is Title VII of the 1967 Civil Rights Act, which prohibits discrimination in the workplace federally. And then you have the Americans with Disabilities Act, which prohibits discrimination against individuals based on an account of a disability, physical or mental. So both laws are in operation. The EEOC, which is the executive agency that's charged with interpreting and enforcing both Title VII and the ADA, several years ago in 2023, they issued technical guidance to employers, issuing a statement about what it means to result in algorithmic discrimination in the use of AI under both Title VII and the ADA. So this is technical guidance that the agency issues to the public to help them understand how to actually implement these two federal laws. And bottom line is that this guidance says there is discrimination in the use of AI. You need to carefully vet the data. You need to carefully vet how the model is built. But it's really helpful in terms of talking about weighing protected characteristics. That's the sort of material point in all of the legal analysis, which is the model that you're using, the vendor that you're using, the tool that you're using, how much weight does it give a protected characteristic under the law? So you sort of first have to start with what are the protected characteristics that we're subject to. California's got a laundry list that the federal law doesn't follow, so you have to sort of figure out where you sit with your employee base. And then from there, what weight does the model give that factor when it's analyzing a resume? And it gets complicated when you're talking about things like zip code, which can be used as a proxy for race, or neighborhood, or region, all the income level that some of these models make inferences about characteristics. So federal level, we have that technical guidance, and then we have that lawsuit pending against Workday in the Northern District that the EEOC actually filed an amicus brief under the Biden administration on behalf of the plaintiff, endorsing their theory of Title VII. So there's still a lot to be said at the federal level. We don't know what the EEOC or the Department of Justice is going to say about Title VII or the ADA because we don't yet know what their position is going to be under the Trump administration. We suspect that it's going to be a low sort of regulatory environment. The states are where all the action is at with employment, legislation and regulation around AI. So this is not a new topic for US states. Illinois, for example, has had a law on the books since 2020 that said if you use AI to interview a person, you have to tell them that there's AI, you have to get their consent to use AI. So that concept of disclosure that you were talking about, that's been around in the US for quite some time. New York City was one of the first jurisdictions on the map in January of 2023 to pass a comprehensive law that says if you operate in city limits and you're making employment decisions about New York City residents, you have to conduct a bias risk assessment. You have to publish the results of that risk assessment on your website. And you have to conduct notice and a consent regime. And there was a recent study by Cornell that looked at how many companies are actually following that New York City law, and I think it was like 18 out of several hundred. So not a lot of compliance happening in New York City on that. California is another jurisdiction to keep your eye on, and that's because California just passed new regulations interpreting the Fair Employment Housing Act in California. So FEHA is the acronym. That is the state counterpoint to Title VII. So this is the state law that regulates non-discrimination, harassment, retaliation for California employees. And if you are a Canadian company and you've got somebody who sits in California, you're subject to that law. It applies to where the employee sits. Now these regulations have been around for quite some time, and they interpret the law and they say, what is discrimination? What is harassment? What is retaliation? They recently just updated those regulations to include AI provisions. And they talk about what is algorithmic discrimination. And what type of risk assessments do you have to complete? Interestingly, for the vendors, they say that anyone who is performing a decision, indirectly or directly, in part or in whole, using AI, is an agent of the employer for agency purposes, and therefore is responsible just as the employer is responsible. Those are on the books and effective now. So that's one area of California law that's developing rapidly. The other is in the area of privacy. So Kirsten, on the privacy panel, they were talking about the different privacy issues. California has a privacy law that's been in effect since January 1 of 2020, and it was updated in January 1 of 2023 to apply equally to employees and job applicants. So anyone who's a California resident is subject to this law if you're a business subject to the law. And what the California Privacy Protection Agency, the CPPA, who enforces the CCPA, is doing is they are considering regulations right now to regulate algorithmic automated decision-making using personal information. And it's a very robust set of regulations that if they pass, and there is a likelihood that they're going to, it would impose extraordinary notice requirements on anyone using AI to a California resident, including in the notice, you have to list out the underlying functionality of the model, how the model works, and how the outputs are generated, which in the generative AI space is a big problem because as the deployers of AI, we don't know how the secret sauce is made for OpenAI. So California is one. Colorado has a new law that takes effect in February that I mentioned earlier that includes employment decision-making as a high-risk use case. So I think the bottom line from the US is that use of AI in any realm of employment decision-making, hiring, screening, mobility, determining when somebody can take leave, which is an increasing use case, monitoring vehicle deployment, all of that is considered high risk in the US. So the bottom line is, harkening back to what Chantal and I were talking about earlier, is having a robust governance process and ensuring your HR department is up to speed on all of these issues and is sort of filtering in what the different vendors are using so the broader risk governance group has visibility.
Yeah, and I think, you say it's high risk. In Canada, it's high risk too. Just because we don't have those laws doesn't mean that. So
you're just as good.
We're getting there. We're following California. That's what we're going to do.
Yeah.
And we certainly have robust anti-discrimination laws, which
Yes.
you're probably all aware of, and we'll talk about that later in the panel about the interaction between AI and your obligations as an employer under, for example, the Human Rights Code.
Yeah, exactly. And before we all got up here, we were having our own sort of nerdy debrief downstairs, and one of the things we found was interesting was, what Peter was just talking about around when a human rights, protected ground is triggered, and almost a percentage metric of involvement in the decision-making process. Well, in Ontario and across Canada and in the other jurisdictions as well, a protected ground only has to be a part of the decision-making process for it to trigger a potential human rights issue. There's no percentage threshold, it's not 50% plus one or anything like that. So employers really need to be thinking critically about how they are starting to incorporate AI-based technology into the exact type of decision-making that Peter's talking about, because that responsibility is going to come back to the employer if it turns out that there is some sort of inherent bias or discriminatory decision-making that's been built into, the AI technology.
Yeah, I think that's a material point between Canada and the US, and really US versus many other jurisdictions. If you're a global company and you're deploying an HR vendor tool and you are looking at it to see if there's a risk of discriminatory outcome, the risk calculus is different in California than it is elsewhere in the US than it is in Ontario. So for example, under the new California regulations, you have to show that the use of the AI was a substantial motivating factor, that's the term of art, which in US legal terms in California courts, that's more than 50%. So it's a substantial motivating factor, not just a motivating factor, which is the rest of the US, and yours is
It's not even a motivating factor.
It's not even a motivating factor.
It could be even 1% of the decision. It could just be an offhand thing. And when you're talking about the way AI works and training models to, say, review resumes, the models can develop a life of their own and start making decisions based on what results are being presented from the data that you've input and from the characteristics that you've input. And that could inadvertently provide you with discriminatory outcomes. And that responsibility ultimately falls on the employer. And at this point, the only real, and this is a bit of a spoiler alert, but the only real solution to that is human intervention. You're going to want to always have somebody reviewing whatever automated processes you have in place.
But we've been talking about use of it in the employment decision-making process, but there's this other element of employment law that comes into issue, and that's employees using AI and not reporting it. There was a survey last year by Microsoft and LinkedIn where they surveyed 24,000 entities globally, and it showed that 80% of employees were using AI, and a majority of them were not reporting it because they thought it was viewed as cheating, or they didn't want to be called out and told they couldn't use the tool. And so I think it's a big employment management problem, which is how do you implement and develop an acceptable use policy that people follow, that's up to date, and isn't talking about prompt engineering with the version of ChatGPT that came out a year ago and is up to date on all the models and capabilities, and educating the workforce. Because I think that is, when I talk to HR managers, the big problem is that they are not actively educating employees about the risks to these models, what the overall company position is on this, and the acceptable use policy was written a year and a half ago. And it's outdated at this point with how prolific and how accessible tools are. For example, does it address the use of DeepSeek, which is a Chinese open source model that folks can use on their personal device? US government has banned it on government devices. What's your company's position on DeepSeek? And so that's where I think there's that using it for decision making, but the bigger issue for all employers is everyone is using AI all the time at an increasing rate, from coders to people in marketing to lawyers, as we've seen in the headlines.
Yeah, no, and that's exactly it. I mean, AI is here to stay. It's not going away. There is an advancement that comes with it. There's growth. It's great and it's exciting. You know, our firm is using AI in many ways in certain contexts because it is acknowledged that there is a benefit to be gained from using that. It's a tool. And so the idea is, you know, an outright ban on use of AI is just not productive or realistic in any workforce. The question is going to be, where do we think it's going to come up? What are the decisions we're making around the different programs that we're seeing? And what kind of a structure are we going to put in place? And most importantly, what are we telling our employees about that structure? What understanding do they have about when they can and can't use it? What can they do? And then from sort of an employee management, performance management perspective, you know, what consequences have been identified are going to arise out of someone who's not following all of those different requirements.
And it's not a one-size-fits-all, right? Because, you know, for example, Larysa talked about using it in a law firm, and we're a regulated profession, and we have professional responsibilities about, you know, utilizing all sorts of technology and disclosure obligations to our clients. But that doesn't mean that you have the same obligations within your own industry, and so companies need to decide what works for them. What kind of output do you want? How do you want it to impact the work that your employees are producing? And there's no right answer, and so I think to Peter's point about staying flexible, nimble, and relevant is really important. It's not something that you can, you know, it's not your Occupational Health and Safety Act that you can dust off once a year and sort of check a box and put back on there. It requires a lot of attention, and that can be, you know, that can be a hurdle for employers because it does feel a little bit like this unwieldy beast. How are we going to cover it? How are we going to stay on top of it? And like anything, I think communication, to Larysa's point, but communication with your employees is key, and setting those expectations very, very clearly in a written policy, as Peter mentioned, and verbally. Make it part of your normal discourse within the workplace about how this is working, how this isn't working. Let's talk about new technologies. Can they be introduced? Should they not be introduced because of whatever it happens to be within your workplace?
Yeah, and I think one area where this risk is manifesting, and Roman touched on it earlier on the IP panel, but I think it bears repeating, is that there are a number of companies out there that are enforcing patents on open source code. So you have developers and companies that are using open source AI, and they're getting demand letters and litigation from these companies that own the patent on the open source code. So this becomes an issue from an employment perspective, because if you have HR putting out a job application notice saying we're looking for an engineer who is skilled in Kubernetes or another open source code, the company is getting demand letters from these law firms saying you've just admitted to using open source code that is protected under patent law. So the HR department doesn't know that. They don't know the risk associated with that. Or you have one of your engineers on LinkedIn posting about their skill set, saying that they're skilled in these certain code sets that are protected under patent law, and now the company gets a demand letter. So the education on the workforce is so critical right now. I mean, if there's anything that you take away is, one, have an acceptable use policy in place. Make sure it's flexible to your workforce and how they're actually using AI, which requires you to ask people, how are you using AI? Which requires people to be honest about it. So there's a lot of sort of psychology involved in getting that answer. But also be clear on educating them on what the specific risks are to the company. I mean, if you're using an off-the-shelf AI training program, which a lot of folks are, because there's all these available plugins now for your online training for cybersecurity privacy. They have the AI training now, and I've seen a lot of them, and they're fine for like the base level, but I do recommend, because the AI litigation landscape is moving so quickly, to have a hyper specialized training for your specific use cases and your data and the tools that you are or you're not authorizing. I think that's really important.
Yeah, I think at its core, talk about it, right? It shouldn't be a taboo topic. It should be something that's coming up
Talk it out.
routinely. Yeah, talk it out. How is it working out? Who's doing what? And ultimately, that's just going to make it easier as an organization for you to then figure out, one, how do we react to anything that is arising in the workplace? But two, how are we going to move this forward?
And I'm conscious of time, so we'll move swiftly along. One piece I want to talk about quickly is, how exciting it is that AI can do things faster than humans. And so that's going to be a very compelling thing for employers as a way to streamline your workforce.
Yeah.
And that brings its own risks, of course, when you start taking tasks away from employees and giving them to an automated system or another employee, for example, but in this case it would be another system, an automated system, sorry. You run into constructive dismissal risks. So just be alive to that as well as you're managing your workforce, as you're implementing artificial intelligence in the workplace. Recognize that taking tasks away from an employee could risk the claim that they've been constructively dismissed, that you've fundamentally changed their employment.
Yeah.
Yeah, workforce disruption is a significant topic right now in the US. You may have seen leaked, or not leaked, but published memos from the CEO of Shopify, of other major companies, announcing to the employee base that they're an AI-first company, or AI native, meaning we're not going to hire anybody until you can prove that you can't do what you want to do with AI. And so there's some pushback on that. Klarna, which is a big company that announced years ago that they were going AI first for their customer service agents. They've recently dialed it back because they realized, I think as was noted in the keynote, decision intelligence does not equal judgment. And that's the big roadblock right now to scaling this. But it doesn't mean that it's not a live issue. And folks are concerned about their job placement, and there's not a headline every day about that topic.
Absolutely, yeah.
So we've talked a lot of broad concepts, a lot of discussion, but we thought we'd close off with a couple of scenarios that just help demonstrate exactly one of many ways in which AI is going to start intersecting with employment law. So I'm going to kick off, or Allison will kick off the first one.
Sure. Excuse me. Now this might look familiar because it's a fact pattern that we're seeing actually play out in some litigation, mostly in the United States. But here we have a situation in which an employer outsources the hiring screening process to a third-party AI company. The employer gives AI its company demographic data to help teach the AI about successful past hires. And despite meeting the prerequisites for the role, the AI company's program screens out 3 applicants as unsuitable. It turns out that all 3 applicants had graduated from a women's-only high school, obviously triggering some potential discrimination based on gender and sex. So we wanted to raise this to try to talk about a practical situation in which AI might cause some friction in your workplace. And as I mentioned, this is a fact pattern that we're seeing play out in the Workday litigation that Peter mentioned, where when you completely outsource your recruiting systems to go through the applications that are being submitted for a role, there can be inadvertent biases that are applied. And in the Workday case, I think the individual applied to something like 100 jobs, and he said he was qualified for all of them, and it turns out he was technically. He also happened to be Black. I think he was over 55. In any event, had a number of protected grounds that, because of the AI system in place, had inadvertently screened him out of every single job. And so what's important is not to say, okay, well, I guess we can't use AI, we have to wait until it gets better. It's that you can use it, you just always need that human intervention. You need somebody, to your point about judgment, you need a human to look at the processes, to review the applicants, and to make sure that there aren't these discriminatory biases coming into play.
Yeah.
I think the challenge in this scenario, though, is the hiring manager, when they get back the report from the vendor tool. I don't know if any of you have seen these reports, but they're saying, well, these candidates are A+ candidates, and these candidates are B, these candidates are C. The HR manager, even as a human in the loop, is not going to sit there and validate the outcome of the vendor. They're relying on the vendor. That's why they hired the vendor. So I actually think in this scenario, if you get this far, you've missed a step, because you should have grilled the vendor on their model and gotten the right contract reps and warranties, as Joel and Matt were talking about earlier on contracting. That's the key protection right now, because in this space, there's not much more you can do. It's already been baked, and I guess you could say, don't make a decision, but what's the point of hiring the vendor tool if you're not going to use it to expedite the decision making? These tools are remarkable. They can scan thousands and thousands of resumes that haven't even been submitted. They're just out there to find a suitable candidate for your role. You post the role, and it goes out and finds a candidate. So you can see how it's very difficult. I think I just hear it from HR managers, like, I don't know what you want me to do when I get this report. So the governance actually has to come a lot earlier, I think, in the HR process.
Yeah, no, I think that's exactly right. And I've worked with a handful of clients where they've already started that process, and it's going back to the vendor, going back to the programmers and saying, what are the metrics? What's the data set? How is the decision making going to work? From an actual operational perspective, you're bringing in your IT people, your engineers, people who will understand that, and working as a team to figure that out, so that, like exactly Peter said, you're not getting to this situation at all. You should be, steps ahead of it and identifying it before it gets there.
And accuracy is the big challenge here, because are they getting it wrong? Half the time. So you see some of these hallucination rates, or I prefer, NIST calls it confabulation instead of hallucination, but essentially, do they get it wrong, and how often do they get it wrong? In that screening process, when you're talking to the vendor, you should ask them, what is your accuracy rate, and do you have any technical benchmarks? Do you have a model card? Do you have something to document how accurate it is? I was asking, so recently I had a client, they were bringing on a new HR vendor tool. Everybody was very excited, and then they brought me on the call, and I brought the party down. And I was like, okay, well, how are we preventing against discriminatory outcomes? And what do you mean by that? I was like, okay, what if you get it wrong? And they said, well, we have a 98% accuracy. And I said, sounds great. Where is that? How do I know that's true? Well, we tried it 1,000 times, and it was right 980 times. I was like, that doesn't sound statistically significant at all. This is a red flag. But we wouldn't have known that question. Everybody was ready to sign the deal. But the vendors, I think Joel mentioned it earlier, vendors have to be ready to answer this question in detail. Otherwise, I do think employers just are taking on a ton of risk. Now in California, they're going to end up being the agent of the employer. So you're starting to see vendors now work around that contractually with California riders. So not to complicate your plates any further, but those regulations now are complicating that even further.
Well, and we might be going in that direction too.
Yeah.
And it is smart to get ahead of it, and you can also include it in your vendor contracts, right? Your right to review the processes, your right to know what's happening behind the scenes, the liability indemnity clauses as well.
Yeah.
Should we do questions?
I
think it's we're tight on time.
Sure.
Yeah.
All right, so given we have limited time, we thought we'd go to questions. And so if anybody in the room has a question for the panel, please raise your hand. And I understand there might be some online as well.
Hi there. I had a follow-up question to your scenario 1, and you sort of touched upon it. Like, how much review is considered meaningful review? So to your point, if you're going through every application, it really defeats the purpose of the tool. But if you're just scanning the prioritization list, is that considered meaningful enough of a review and enough of a human in the loop to take it out of the exclusive automated decision-making definition?
Yeah, I think in my view, you should not be leaving to the HR manager who is reviewing the results and scheduling interviews any of that governance check mark. So I think all of that governance work should be up front. One, there should be a strategic review by C-suite and others as to, is this the type of AI that really is forwarding our purpose? Do we want to be using it strategically? And then that should then go to an operational review, which is what guardrails do we need in place in order to ensure that this tool is effective. That operational review is when you do the diligence on the vendor and you build out your contractual protections, you've got security protections, you've got IP and privacy involved, the employment council. Once it gets to the HR manager to use the output, they shouldn't have to be thinking about all those risks because that's not part of their job and they're going to get it wrong. So I do think that sort of meaningful review needs to happen before it's being used. If it's being used without that meaningful review, I think that's where you carry the most risk, at least in today's legal environment.
Yeah.
And I was just saying, it's not to say that the meaningful review shouldn't happen. I think that there are several places that you need to engage in the process. But I think the big takeaway is that a court or tribunal, if you're faced with a discrimination claim, is not going to be terribly compelled by how much meaningful review you did if a discriminatory practice was in place anyways. So it's difficult to quantify what that looks like if there is some sort of bias that's baked in. Yeah. See one at the back?
If your system, if your AI system, for example, you put in a query, I want the top 20 candidates, and it just so happens that person is that person who's sued, right? For example, and every company that did that, we want the top 20, and that person did not fall within the top 20. Is that considered bias?
So in this scenario, the person that applied does not appear in the top 20 for all of those companies?
For anybody.
Yeah. So if that person were to hire me as a plaintiff's lawyer, which I'm not giving any plaintiff's lawyers ideas in this room, what I would be looking for is, did the model result in the fact that my client was excluded from the top 20 because it took into account, either directly or indirectly, a protected characteristic? And if so, there was a disparate impact on my client's group of employees. And so you could file a class action lawsuit in California without having to prove other people suffered the same result, but enough to get forward in that case. And that's what happened with Workday. Workday is conditionally certified as a class action based on that theory, even though there's like 5 named plaintiffs in that case. They're seeking to represent everybody who suffered the same result. So that's probably how it would proceed.
And the burden in Ontario, the burden of proof switches to the employer as soon as you have that ostensible discriminatory act. So, to that situation, you can say, look, it looks like I was discriminated against, and then the burden of proof is going to switch to the employer to prove the negative, and that speaks again to our very low threshold.
Yeah, and that's where, again, at that pre-negotiation stage, when you're talking with the vendor before you've actually signed the dotted line, that's where those questions are coming up. You ask them, how are you deciding who is going to be put forward? How are you deciding who isn't? Those are the types of questions, and run through those scenarios to yourself get a better understanding so that you can be more comfortable with how that is going to be used going forward.
Okay, all right, so we've got an excellent online question here. How are employers thinking of job reductions that are due to AI? For example, Microsoft has been public about its job reductions that are owing to AI. What percentage of these reductions have come with challenges to the AI on discrimination grounds?
Yeah, I don't know that we can answer what percentage would be on discrimination grounds, but we are seeing a big trend in sort of tech readjusting their labor workforce, especially in the coding space for engineers, because the coding agents and the AI tools are so powerful. I would say we don't know whether any of that's discriminatory, obviously, because we're not inside those companies. But I do think when you're dealing with large-scale layoffs as a result of new technology, especially in California, you will get lawsuits. Like, it will happen inevitably. And I think the key there is going to be how did you arrive at that determination? Oftentimes, when technology is replacing employees in the US, it's an age discrimination lawsuit. But here, it's not so much replacing people based on age, it's pure job function. So if you're replacing somebody completely as a job function, and you're eliminating the whole workforce, there's less of a risk there's discrimination. But if you're keeping on 5 people who are under the age of 30 and everybody else is gone, then plaintiffs' lawyers sort of jump on that narrative, and that forms the basis for the lawsuit.
Yeah, it's interesting. I mean, especially if you're a public company, you're under a lot of pressure and have to disclose the results of your AI investments, right? But it's a good news, bad news story because that's kind of fuel for the fire for potential lawsuits from employees.
That's right.
Yeah, or governmental action.
That's
yeah.
right.
Okay, we are at time, but thank you. That was amazing. Peter,
everyone.
Allison, Larysa.